Okay, Netta, the floor is yours.
Okay, so I'm really glad and happy to be here today again to discuss a panel which I'm sure is going to be really fascinating because all of the papers are so good. So we're going to discuss complicity and deliberate ignorance. And the papers also work really well together, I think, as we'll hear immediately now. And our first speakers will be Eyal Zamir and Yair, and we'll talk about deliberate ignorance and the law.
Thank you. So I should warn you, I have other papers which are interesting. It is just that the organizers insisted that I present this survey of how the law treats deliberate ignorance as a warm-up act for the main presentations at this session. So this is based on a chapter that was prepared for a conference in Germany on deliberate ignorance. By deliberate ignorance, I mean the conscious individual or collective choice not to seek or use information. The emphasis is on situations in which the cost of acquiring the information is rather low. So according to rational choice theory, we would assume that people would be happy to have more information, but this is not always the case. One preliminary comment that I would like to make is that the borderline between deliberate and non-deliberate ignorance is often unclear due to all kinds of biases, like the confirmation bias, the motivated reasoning, etc. We are not always sure whether ignorance is deliberate or not, but I'll put this to one side. As for how the law treats deliberate ignorance, so basically the law either tries to discourage deliberate ignorance sometimes, but at other times it actually strives to facilitate deliberate ignorance. Yeah. So I'll start with the first goal of the law and then move on to the second goal. So for both corrective justice and utilitarian reasons, the law often imposes greater liability for acts that are done deliberately with full knowledge of the relevant facts and their expected consequences than on acts done without such knowledge. Alas, such rules obviously create an incentive to remain ignorant in order to evade liability. The law reacts with three types of means to counteract this incentive. The primary technique is to treat people who could have acquired the relevant information as if they acted knowingly. The second technique is to impose positive requirements, positive duties to obtain the information. And the third one is to render information more salient, thereby making it more difficult to ignore. Starting with the first technique, there are two ways to equalize the treatment of deliberately ignorant and knowledgeable actors. One is to treat deliberately ignorant actors as though they were aware of the relevant information. The other is to lower the threshold of liability by dispensing with the requirement of actual knowledge in favor of an objective standard such as negligence-based liability or even strict liability. Let me elaborate. So under the doctrine of willful blindness, the requirement of knowledge is satisfied when a person suspects the existence of a fact, but deliberately avoids looking into it. For example, some legal systems criminalize the knowing exposure of sexual partners to the risk of HIV transmission. Such liability is also imposed on people who suspect that they carry the virus and deliberately avoid testing it. When the willful blindness doctrine is mostly applied in criminal law, it is sometimes applied in private law as well. For instance, the doctrine of market overt protects the good faith purchaser of stolen goods. This protection is granted to buyers who do not know that the goods were stolen. However, for that purpose, willful blindness by the buyer is tantamount to actual knowledge. Another relevant doctrine that might be of interest to some of the people here is collective knowledge in corporate criminal law. This doctrine allows the court to find that the corporation had acted knowingly if the aggregate knowledge within the firm among the various employees was sufficient for that purpose, even if no single individual within the firm actually had all the necessary knowledge. And this doctrine discourages manipulations of distribution of information within the firm in order to avoid legal liability. Private law is usually more interested in facilitating fair and efficient behavior than in moral culpability. And so consequently, it often treats those who should have known something as if they actually knew it. For example, when people enter a contract as a result of improper threats, they're entitled to cancel the contract. Typically, the threat comes from the other contracting party, but sometimes it comes from a third person. So for example, a husband may threaten his wife that he would leave her unless she sells her jewels and gives him the money. In such cases, the wife, under the statement under the law, the wife can cancel the contract only if the other party, the jeweler, knew about the husband's threat or had reason to know about it. So this rule removes the jeweler's temptation to go on with a suspicion, to make a profit out of a suspicious transaction. Imposing negligence-based or even strict liability similarly discourage deliberate ignorance, because ignorance just won't protect you from liability. Such regimes create incentive to avoid the harmful conduct and to acquire the relevant information in order to do that. To be sure, there are numerous other considerations for and against establishing such liability, which I will not discuss now. So this is the first tactics that the law uses to discourage deliberate ignorance. The second way is to impose duties to acquire information. So that those measures can be taken instead of or in addition to the imposition of liability, as I mentioned thus far. So sometimes the law imposes specific duties to obtain information and sometimes even dictate the procedure for doing so. So for example, laws against money laundering require financial institutions, lawyers, and other professionals to complete a process of customer due diligence. The mandated protocol requires the documentation of detailed information about the customer and the transaction or the business that the customer seeks to engage in. If this information raises suspicions about the nature of the transaction, there is an obligation to report to the authorities. Similarly, the law often requires an environmental impact assessment before approving any enterprise that might adversely affect the environment. And quickly moving to the third technique, sometimes there is no sufficient basis for using legal sanctions, but the law still wishes to encourage desirable information, behavior and discourage undesirable behavior. So when people engage in undesirable conduct because they are ignorant of the outcomes of their behavior, possibly deliberately so, providing them with the relevant information may induce them to change their behavior. Sometimes the state itself provides the information, sometimes the state mandates others to do so. So a case in point is the provision of salient information about the hazards of cigarettes. Another example is a simple and uniform system of conspicuous signs on products which grade them in terms of their health impact, and such signs may hopefully discourage the consumption of unhealthy food. So in the picture you see in Israel, there are those red circles that should be put on food products. And this one is about sugar. So it indicates that there's a lot of sugar in this product. And as you can also
Which is
see,
a good thing, right?
The company put it on.
No, the company actually, they find ingenious ways to counteract, to dilute the effect of the red circle. And this is by adding the light blue circle. So people imagine, oh, there's something bad, but there's also something good about that. And the good thing is that there are no sugar substitutes here. That's what that's it.
Dan called it fudging the nut, which is really appropriate for Ben and Jerry's.
So until now, I discussed situations in which the law strives to discourage deliberate ignorance, but sometimes it strives to facilitate it. And here are a few examples. So people often make decisions that affect not only their own interests, but also the interests of others, which often results in conflict of interest. One technique for handling such conflicts is to keep decision makers ignorant of how the decision is going to affect themselves, a kind of veil of ignorance. So take, for example, the separation between a constitution and ordinary legislation. This separation may be viewed as a means of establishing fundamental norms of government, protecting human rights, at a point in time in which the people who make the constitution do not know yet whether they are going to benefit from it or to be adversely affected by it. A similar rationale may hold for the separation of power. So the legislature enacts general norms, and then the courts and the administration implement them in specific circumstances. And so this separation also supposed to make it more difficult for the legislators to figure out whether they are going to benefit or be harmed by a certain legislation. Finally, sometimes a two-stage decision procedure is adopted for the same purpose. So, for example, the cabinet might first decide on the size of a critical budgetary cut and postpone the decision as to how to allocate the cut among the ministries. Otherwise, they wouldn't be able to make the initial decision. By separating it to two stages, it sometimes works. Another context in which the law deliberately ensures ignorance is admissibility rules in the law of evidence. These rules prohibit the presentation of certain pieces of information to the court. Sometimes these rules aim to exclude unreliable information in order to improve fact-finding. So perhaps the rule against hearsay aims to improve fact-finding. But at other times, there are other goals, competing goals, that inadmissibility rules foster, such as deterring the police from obtaining evidence unlawfully, or protecting special relationships, such as between lawyers and their clients, physicians and their patients, and so forth. Blinding techniques are also used in the process of gathering and preparing the evidence. So a primary example are double-blind lineups. Eyewitness testimonies often play a key role in trials. However, reliable identification hinges on accurate encoding, retention, and retrieval of information, all of which are imperfect and prone to biases. One specific danger is that witnesses who are asked to identify a culprit in a lineup are influenced by conscious or unconscious clues given by the administrator of the lineup. An effective way to overcome this danger is by conducting double-blind lineups in which the administrator does not know who the suspect is either. The notion that some types of information may obviously affect the impartiality of decision makers extends beyond the courtroom. For example, employers who recruit new employees, scholars who review their peers' manuscripts for publications, professors who grade their students' papers, they are all vulnerable to all kinds of biases. Unidirectional and sometimes even bidirectional anonymity may solve the problem or exclusion of information. So if you don't know what the ethnicity or the religion or the sexual orientation of an applicant, then not knowing it protects the process from such biases. So in our survey, there are many more examples. For lack of time, I'll only mention briefly some of them. So there's the expungement of criminal records. in order to let people start from a clean slate, recover from their, not to be haunted by their criminal records. A rule that was probably enacted by lawyers is that attorneys are considered to, it is okay for attorneys to turn a blind eye on perjury by their clients. So in that case, it is considered okay to deliberately ignore the lies that your client tells in court. And finally, to induce settlements in plea bargains, the court must not disclose the parties how it might decide the case if there were no settlement between the parties, and that connects to some of your work, Ilana. So the key advantage of settlements and plea bargains is that they protect the parties from the expected cost of regret. So if I get a settlement offer, if I reject the offer, then in retrospect, I might hate myself for doing so because I did much worse in court. Whereas if I accept the settlement, then I'm protected from the cost of regret because I would never know how the court would have decided if I rejected the settlement. So this is a very attractive aspect of plea bargains and settlements. And to make this work, and courts, of course, have a strong incentive that people would settle, judges must not give any information how they might have decided the case if there were no settlement. So this is my warm-up act, and that's it. Thank you.
Thank you very much. Right on time. I think that because we have a respondent in this session, we'll collect the questions and do that at the end. Does that sound okay?
Yeah, that sounds
okay. So on that note, I'm happy to transfer to Max Bazerman, who will talk about profiles of complicity. And Yuval and Jennifer, I have you on my queue.
Maybe by mistake.
from the previous question. Your hand was up, I'm aware.
I'll get on the queue instead of you.
Okay. Not my mistake. Okay. Max, you're on mute.
Max, we can't hear you.
Can you hear me now?
Yeah.
Yes.
Great.
Okay. Somehow I lost the mute control, so I'm using the space bar as you've all just taught me. So we'll see if that works. Thank you for including me. First, I want to thank the organizers. This has just been a terrific conference, and what a nice connection between the legal community and the behavioral ethics community. It's something that I haven't encountered before in my career, and it's kind of profoundly useful. And I've learned so much from so many of the legal talks, like the talk we just heard in Jennifer and Yotam and Donald yesterday. So that's great. I'm going to give a talk on a book that I'm predicting that I'll publish in 2023 called Profiles in Complicity. That means that most of the book is not written and I don't have a contract or anything else like that. But this is what I spend my time working on. It kind of started in the aftermath of the 2020 election with a lot of things that we kind of observed. And I'll get to what it's about, but you can kind of, hopefully the title is relatively this.
Max, we stopped hearing you.
You're again on mute.
Okay, now you can hear me, is that correct?
Yes.
Okay, and you can see my screen, including,
Yeah.
And it just moved to Erica Newland. Do you see that?
Yeah.
Okay, excellent. We're in good shape now. So sorry for my technical incompetence. So I want to tell you about Erica Newland. She's a lawyer. In 2026, she was a 29-year-old recent Yale Law School graduate who took a job in the DOJ, clearly expecting Hillary to be the next president. The office that she took a job in was responsible for nonpartisan assessments of whether presidential executive orders and other executive actions were lawful. Newland, a self-described civil libertarian, believed in constraints on presidential power. She was surprised by the Trump election in 2016, but she stays on her job, believing she would play a valuable role by scrutinizing Trump's policies. And she put up with the fact that around the office, she would hear things like, "We're just following orders. I know that's what the Nazis said, but we're not Nazis." So that's kind of the environment she was in. She began to hate her job, developing the views that rather than providing a defense against egregious racism and shaky policy, she was actually using her skills to launder Trump's false statements. She also felt that she and other career attorneys were being used to legitimize repugnant policies, including the Muslim ban. Then in October 2018, a white supremacist opened fire in a Pittsburgh synagogue. That's actually the neighborhood I grew up in, killing 11 people. And Newland then concluded that the work she had been doing was sanctioning rhetoric that had inspired a mass killing. 3 days after the shooting, she quit her job. So Newland has been covered by a writer by the name of George Packard in The Atlantic, but she also published her own editorial after Trump lost his reelection, where Newland apologized to all of us for her collaboration and described her descent into complicity, where she wrote, "I never harbored delusions about a Trump presidency. Mr. Trump readily volunteered that his agenda was to disassemble our democracy, but I made a choice to stay at the Justice Department for as long as I could bear it. I believe that I could have better served the country by pushing back from within than by keeping my hands clean." Then she goes on to say, "No matter our intentions, we were complicit. We collectively perpetuated an anti-democratic leader by conforming to his assault on reality. We may have been victims of the system, but we were also its instruments. No matter how much any one of us pushed back from within, we did so as members of a professional class of government lawyers who enabled an assault on our democracy, an assault that nearly ended it." And the entire editorial is an apology for her complicity, which I find kind of remarkable. I did follow up my reading by spending an hour talking to Erica on Zoom, and I think she's a remarkable young attorney. I just find it fascinating that this person, who I think was a really good person trying to do good things, sees her own complicity in her actions while she was trying to do good things. And I find this as a contrast to so many people who I'm going to argue are complicit and hide from their own complicity. And this then has implications for the laws that Eyal or Jennifer might recommend to deal with this kind of environment. Okay, so I actually have two starts of the story. One is to tell you about Erica Newland and the need to think more about the complicit. The other story I want to highlight is kind of what I see as the history of the behavioral ethics literature over the last couple of decades. On the one hand, we have the media basically highlighting the truly bad apples out there. Adolf Hitler's a little bit old for this story, but highlighting sort of Donald Trump, Bernie Madoff, Adam Newman, Elizabeth Holmes, Richard Sackler, Harvey Weinstein. You can pick your own really bad people out there. And yet the field of behavioral ethics, which has been referenced repeatedly, really hasn't talked much about these actors. In fact, you often hear the phrase, we need to move away from the search for the bad actors. And I think that part of the reason for this move is psychologists don't know very much about how to keep someone from becoming a truly bad apple. So since we don't know what to do about it, we switched the task and we switched to looking at what's emerged as the field of behavioral ethics. I think that this overlaps with the soft-hard discussion we had yesterday, although I'm not exactly sure we were all using soft and hard in the same way. But the behavioral ethics field develops, and certainly I think of myself as part of that literature. Much of kind of day one and day two focused on sort of specific experimental games, I'm going to focus on sort of one definition of bounded ethicality, which a term created by Mazrin Benaji and R. Bhaskar, but defined by Dolly Chug and Mazrin and myself as the systematic and predictable ways in which humans act unethically beyond their own awareness. So this kind of brings all of us into it. I think that there's another part of behavioral ethics of people intentionally doing what we think of as small bads or ordinary bad activities, even if they are in awareness. I'm not going to really separate the two. My focus has been more on bounded ethicality specifically, and these are some of the books that summarize what we know from the bounded ethicality world. So what I want to argue in this talk is that I think behavioral ethics gave up on the bad actors too quickly because we didn't know what to do, and we found another activity to focus on. And I think that the bad actors, unfortunately, create enormous harms. And I think stopping bad actors needs to be part of our agenda. Obviously, the lawyers in the group recognize that and see that. I think that the behavioral ethics world moved more sharply away from that. And I want to return to how I think we can contribute. And the simple argument that I'm going to make, again, inspired by the complicitors to Donald Trump, is that we need to identify the multitude of different people who allow the bad actor to do their harm doing. And that without these complicitors, the bad actors are far less likely to get away with their action. So what I want our future lawyers and our future psychology majors and our future MBA students to do is to view it as their obligation to be far less complicit or to avoid complicity entirely. And what I'm going to talk briefly about are 6 different profiles in complicity. I think on the front end, you won't recognize yourself, but my guess is you'll recognize yourself by the time I get to the last, among the last 4. And so I've been writing drafts of most of these chapters, and I envision my work for the summer as thinking about what do we do about it. And so much of what the lawyers have been talking about has been useful to me as I begin to try to think about what can we realistically do about these forms of complicity. But I do think it's useful to highlight what these look like so that we can all do a better job of identifying when we may be complicit or when we may be creating systems that can predictably lead to complicity of others. So in Eyal's talk, in Eyal's paper, which I had an excellent opportunity to read, he talks about organizations could create systems where character A creates the context in which character B sort of engages in the bad behavior, but B doesn't even know that she is engaging in that bad behavior. So I think it's important to understand the different complicit roles if we're going to get people to be less complicit and therefore stop the bad actors in the future of acting. Okay, so I'm going to get on with a very quick tour. I'm obviously happy to talk about any of these in more detail. Oh, but the final thing I want to sort of highlight is I'm really thick-skinned. I'm often critical of others, but I'm also pretty good at receiving criticism, and I'd love help. So if you have great stories to tell me, if you have arguments against me, it's great to hear that. Again, I'm telling you about my 2023 publication that I hope will exist. Okay, so the 6 types of complicitors. True partners, I'm defining true partners as people who want the same thing that the evildoer is doing. Okay, so for Donald Trump, I think of Steve Bannon, who was largely in favor of both the white supremacist agenda of Donald Trump, but also in favor of reducing the degree to which our system was democratic, much more prone to authoritarian leadership. The Sackler family, or Purdue Pharmaceuticals, if you don't want to treat this personally, had distributors, physicians, and pharmacies who wanted the same thing that Purdue Pharmaceutical wanted, the most distribution possible of these pills, which allowed them to profit. And Eric Eyal, there are a number of terrific books about Purdue. A new one just came out actually called Empire of Pain by Patrick Keefe. But for my talk, I think Eric Eyer's book, Death in Mudlick, is most intriguing, where he focuses on the role of distributors, physicians, and pharmacies. And without them, Purdue simply would not have been able to get their pills into the hands of the people who abused and overdosed from the drugs. Closely related to True Partners, and you can certainly think of this as on a continuum rather than a dichotomy, are collaborators. And the distinction I'm making here is collaborators often don't want the primary harm that the harm doer is creating. They're simply willing to tolerate it to get other things that they want in return. So you can think of this as a negotiated log rolling activity. So as much as I despise Mitch McConnell and Lindsey Graham, I don't think that their core goals were a white supremacist society or destroying democracy. But in order to pack the court with conservative justices, they were certainly willing to put up with white supremacy and the destruction of democracy. Charles Duhigg, in a recent article, does a great job of highlighting how the venture capitalists played such a critical role in allowing Adam Neumann to defraud the world about the nature of what was going on within WeWork. And if you don't know that story, it's kind of an amazing story. And Adam Neumann is hiding somewhere in Israel now to get away from lots of legal claims that would be made from him in the United States.
He's going to join us for dinner, Mats.
I wish I could be there. So benefiting from privilege, I'll move to a comment on Black Lives Matter movement in a moment. But I want to tell you a story about Lee Ross. So Lee Ross, who was a great social psychologist who passed away this past week, was a friend. But the story I want to tell you goes back to 1990, when I was invited to give the Wednesday afternoon seminar in the Stanford Psychology Department. And for those of you who know a lot of my work, you can easily imagine that sort of Amos Tversky was one of my heroes. Kind of Howard Rafa, Amos Tversky, and Danny Kahneman are my intellectual heroes. And I was completely obsessed with the fact that Amos was in the audience for the talk. And I knew that something that I was going to say was in disagreement with some of his research. And I was clearly obsessed. But Lee Ross was my host. And Lee Ross was already a famous social psychologist by this time. And he had a doctoral student, a guy named Rob Robinson, who had just taken a job at the Harvard Business School. And at the time of the story, and largely to today, in the US, business school professors are paid dramatically better than psychology professors. And it's clear that Lee was obsessed by the fact that Rob Robinson was about to take his starting job at a higher salary than Lee was making as a very famous tenured full professor. And my talk included the term social comparison processes. And Lee basically introduced me with sort of a nice introduction and said, and hopefully you'll explain how you justify this ridiculous disparity between business school professors and psychology professors. And he, in the middle of the talk, he asked a question about that. And he closed the talk with a sort of a gracious closing and said, "Thank you, Max. That was a very nice talk, but you never really have answered why business school professors are entitled to so much more money than psychology professors." And there was then a kind of a large group dinner. And then after dinner, we returned, just the social psychology group at Stanford and myself returned for a seminar to continue talking about the themes from my paper. And that talk led to this publication of Diekman, Samuels, Ross, and Bazerman. But what was interesting is it was a very agitated discussion. And Lee finally said to me in kind of a quite irritated tone, which led to this publication, he said, "Max, what really pisses me off is that up until this discussion, you've never even thought about the fact that you're so overpaid." Now, some of you will think, no, it's kind of battle pay for teaching MBA students, and you make your own choices. And it's certainly true that Lee was very hireable by a business school if that's what he wanted. So we make our choices. But what's clear is that there is an injustice from the perception of one side. And Lee was correct. I had never thought about myself as being unfairly overcompensated because business school professors were treated better. And that, again, that led to this paper, which basically sort of explores that notion. And if you had asked me 3 years ago whether I considered myself privileged, I would have said no. I mean, I grew up relatively not well off. I wasn't given sort of amazing academic opportunities as a young kid. And I found my way, and eventually I had a number of lucky circumstances, which you can call privilege. But when the Black Lives Matter movement began and accused lots of liberal white Americans as being privileged, a lot of liberal white Americans didn't like that. Okay, they didn't like the label of privilege. They were sort of happy to see affirmative action, but the word privilege bothered them. And I think that my story with Lee kind of gave me perspective, so that, if you ask me now, am I privileged? I would say in lots of ways, that I sort of hadn't thought about to the detail that I would see now. So one other group that I think is privileged are people who end up in kind of elite positions of the type that most of us have as university professors. I was also inspired by McKinsey's role in the Purdue story. So basically, McKinsey advised Purdue to do most of the key pieces of evil that they engaged in. And then they tried to protect themselves by the claim, we just give advice, the client makes the decision. And I think that that's really a privileged position to be able to take tens of millions of dollars of fees and then deny the role that you play in the harm that your harm doer is created. So obviously this is a long and complicated topic.
Matt,
yes, please.
As much as I would like it to continue forever, we need to sort of wrap up in a few minutes. We're a little
okay.
bit...
Then I'm going to go very quickly.
I want to go to dinner.
So believers are people who defer to the evildoer, not because they've thought it through, but because they simply put faith in the evildoer as a heuristic. And I was going to go from stories in the cult realm to the corporate realm in terms of the amazing people who had faith in evildoers. So that's profile 4. Profile 5 is people who defer to authority and loyalty, and I'll simply defer you to Adi's excellent talk yesterday, where he talked about the role that loyalty could play in allowing evildoers to do their thing. And then finally, when evil is out of focus, I'll show you one picture of that. When I give people this chart and ask them which fund to invest in, they pick fortitude. And if I ask them, but is it possible to outperform the market to dramatically outperform the market over a 9-year period of time without any volatility? They say, of course not. And I say, well, that's what people didn't notice about Madoff, because fortitude is basically Madoff's returns. And when you focus on high returns and low volatility as good attributes of investment, you may not notice that the returns aren't possible. So I'm happy to sort of end there. And again, I'm happy to listen to the discussion and respond, but I'm also happy to get your stories and arguments and criticism. So thank you. And sorry if I talk longer than I was supposed to.
Thank you very much. Okay, so minutes time. So Ilana will talk now about looking the other way, information avoidance in other oriented decisions.
Yeah.
Okay, so ending the day with experimental sort of heavy chapter, I must say it's maybe not ideal, but bear with me for a little longer. So I apologize for this, and I have to also apologize for talking about only one experiment, and for the very few people who actually saw or read the paper, I'm skipping experiment 1 because I discovered the coding error. So one of the worst things that could happen to you, no other than being hit by a rocket or
We didn't circulate the paper, nothing you didn't even have to say.
right, but I was, I was in a
How
I
does
was
it compare to
shell-shocked.
bad coffee?
So as I was preparing the talk, I realized there was a mistake there. So if you had read the paper, please erase from your memory experiment 1, or at least treat it as inadmissible evidence. I'm not completely sure I give up on it, but I have to read with the comments. But I am fairly certain about the experiment I will present today. Okay. So, well, actually, I'm not sure I need all this introduction because Eyal already introduced the whole story of deliberate ignorance. So past research on the phenomena explored avoidance of knowing the consequence, or most past research looked at avoidance of knowing the consequences, and there are other, and the generally accepted account for deliberate ignorance is the need or the motivation to maintain a moral self-image. So avoiding information regarding the consequences of one's choice for others can provide moral licensing for actually a self-interested choice. But there are lots of relevant information. So it's not just the consequences, the absolute numerical consequences that may matter, but also other aspects of the situation. So, for example, many public policy decisions do not fully take into account who the potentially affected people are, which may be important. So just from today's Haaretz paper, for example, headlines. Oh. Okay. So I can't see it. Okay, so just from today's headlines, shelters from the rich only. Of course, the policy was not to give to give shelter only for the rich, but in effect, what happened is that the existing policy ended up helping only the rich get shelters, or unemployment benefits only for some, right? So, so there are many situations like this, but the present research focuses not on the consequences themselves, but on information about aspects of social identity of people who are potentially affected by the decision. So who the affected others are. I'm skipping a bit to make it show. The present research explores a specific type of social information that decision makers may prefer to avoid, which is the social status, and in particular, the source or the cause of the social status of the potential recipients of it. Okay, so why social status? First of all, there's a lot of research that shows that high status actors generally tend to be less generous than low status actors, although this has been contested. It's not, there's no complete consensus about this, but there's enough research to show that under some circumstances, but what's more relevant to the experiment I want to describe to you is that a recent paper by Paul Piff and others claims that people's attitude towards the less well-off individuals is affected by their perception of the reasons for the individual's current situation. So perception of poverty is primarily determined by dispositional factors. I'll call it blaming the poor, okay, is associated with justification of inequality in terms of enlightenment. And they have a nice study that shows this at the country level. So I'm not sure you could really see that, but on the x-axis, there's the tendency to attribute poverty to situational factors, going from left to right. On the y-axis, there's support for inequality, and they show that in countries in which there's a greater tendency to attribute poverty to dispositional factors, there's more tolerance or even support for inequality. Okay. How does this relate to information economics? So on a personal level, a selfish decision maker who knows her choice will negatively affect a poor person may find it especially disagreeable if she knows that the poor person is poor only due to bad luck. In contrast, if that person is poor because they did not try enough, the selfish decision maker may not feel as bad. So the question that this experiment addresses is, would a decision maker who has the opportunity to help a poor person want to know whether this person is poor due to pure luck or due to inefficient effort? Is there a motivation to find this information or avoid it? Okay, so the experiment, sorry, it's a bit complicated. First manipulated social status in the lab. So we are not talking in the real world, but we are talking in the lab with real money. Okay? So participants initially complete sequence of tasks, such as how many L's in this row and so on. All of them complete the task, and then they receive or do not receive a bonus payment for this task. Okay? So participants received or did not receive the bonus payment based either on their performance or on the random lottery. So I'll skip reading the instruction. If you're told that someone did not get the bonus payment, you don't know if it is because he didn't or she didn't try enough, or because they were just not lucky in the lottery. Then next, participants were anonymously matched for a dictator game, where the dictator was selected among participants who received the bonus, and the match participant was selected among those who did not. I have to say, well, there are not many economists here, so I'd say ostensibly. Right? The reason for the recipient, sorry. Okay, the reason for the recipient not receiving the bonus was either poor task performance or random draw. Now, the main manipulation here, besides this, is whether the information about the reason for the recipient not receiving the bonus was overt. So you were either told you didn't receive the bonus because his performance level was low, or because he didn't win the lottery, okay? Or you're told it is unknown, but you can't do anything about it. But in the other second condition, the concealed presentation mode, you don't know initially why the recipient did not receive the bonus, but you can find out by hitting the reveal key, and 81% of the participants there chose to reveal. So what the interesting question is, how does the information or lack of it affect mainly affects the decision in the dictator game to give or not to give. And I have to say that a little over 50% did not give anything. So I analyze and present the data in terms of dichotomous decision, either to give or not to give. It's similar when you look at the results are similar when you look at the continuous. Okay, so here's really the main result. So what we have here is on the x-axis the reason for the recipient not receiving the bonus. So either it's performance or luck or it's unknown. And on the blue bars, you have the concealed condition where they did, the respondents did not know it initially and they had to reveal the information, whereas the red bars show the conditions where the information was given explicitly. Okay. And what you can see here is that there's one case in which you see a big difference between the two. And this is the unknown, the part of the unknown conditions, meaning those respondents, either in the blue or in the red bar, did not know why the recipient did not receive the bonus. But in the blue bar, they did not know it because they deliberately decided not to know it, whereas the red bar shows the decisions of the people who were just told you don't know, okay, but were not given the option to find out. So basically, not knowing by itself does not tell you about the generosity of the decision maker. There's a big difference between not knowing because you don't want to know and not knowing because you're not told. Right? And this is the main, the main result here. Netta, do I have more?
Yes, you have about 3 minutes left.
Okay, so I'll go quickly over the next thing. So you may ask, well, what are the determinants of people's decision to reveal the information? Not deciding to give or not to give, but the very choice of revealing or not revealing the information. And of course, for that, I could only look at the covert condition. And there's two possibilities. First, concern for the other may engender search for information regarding the cause of the current situation. If you care, if you are concerned about the other, you want to know, right? On the other side, you have the attitude regarding the causes of poverty. If you believe in dispositional account, you may be more willing to look at the cause than if you don't. And okay, so first of all, results regarding the concern for others, as expected, people who revealed were the ones who showed more concern, right? So you see that the mean concern is higher for those who revealed. Okay, what about the attitudes, all right? You have to measure those, right? And that's what I did here. So I used the scale, I borrowed the scale from PIF and others. We have a series of statements like this, and the question is basically how important is each of the following as a cause of poverty, and people have to rate this, and you compute a mean from all these ratings, right? A related notion is the notion of a sense of entitlement, and they are of course highly correlated. And if you haven't seen the standard scale for the scale of a sense of environment, I think it's pretty funny, but it sort of works. The most potent statement here is, if I were on the Titanic, I would deserve to be in the first life.
Is that a 1 to 7 or 1 to 7 scale? And the mean is?
I mean, those are just examples. It's a longer list of statements.
Something like I deserve to be an academic.
That's a good one. I'm not sure that everyone will agree about the virtues of on the other hand, on the Titanic, I think everyone would agree that
You can
it is basically on the line. Okay, so I think this is an interesting finding where the people who reveal are the one tended to be the ones who blame the poor, right? So if you blame the poor, you're more likely to reveal the information. I'm not completely sure that I have the whole story, but it's an interesting finding, I think. And the same with the sense of entitlement. And just to finish, I'd say that the concern for the other is not significant, at least in this sample, was not significantly correlated with the attitude about poverty, which you might expect. And they both independently predict revealing. Okay, so you have different determinants of why people decide to look at information. Or you can flip it around and say that different reasons why people decide not to look at the information. Okay, so just to summarize, the effect of missing socially individuating information about an affected other, in this case the cause of poverty, depends on its potential availability. Self-interested choice is more prevalent if the information is deliberately ignored than if it's simply missing. And determinants of seeking or avoiding information may be related to one's attitude regarding the normative role of the missing information. This requires more research. Thank you.
Thank you. So we would now turn to Ray Shapira, who will provide comments on the 3 papers. So, boy, you have 10 minutes.
Thanks a lot. Okay, disable.
Thank you.
So I'm disabled. Could you allow me to share the screens?
Stop sharing.
You're not co-host? Maybe we can.
I would
Yeah,
love
just
to
make
add
it
it.
co-host.
Give me all the power, Ivan.
No, I'm not the.
Oh, you're not the.
No, it's shine.
Maybe I can.
The share screen doesn't leave.
No. Save.
You go to security.
Yeah, that's not all.
Oh,
No, but I'm not the
No,
host.
now I change it. Try now.
Oh, you were
Oh, you're
sharing?
the host?
Oh,
No, I
okay.
want the host, I should just
Yeah.
enable you.
Eyal, great enabler. Okay, thanks a lot. Great facilitator. All right, thanks a lot. So, I'm officially the last official speaker on the program, which, yes, and Gidon.
And you already know that Gideon is hungry.
Yeah, he doesn't stop talking about it. So, it means two things.
Is it
First, I
that
get to, echo, Max's thanks to, Adi and Yuval and Gidon and Barak, who's not here, right? For organizing this, great workshop throughout the year and this conference. Second, it also means that I won't take too much of your time. I have less than 3 slides. And in these 2.5 slides, what I'll do is instead of trying to poke specific holes in the papers, I'll try to bring us together to the namesake, to corporate law, to corporate governance. So we just heard about 2 important vectors in behavioral ethics, like deliberate ignorance and complicity. So how does corporate law address them, if at all, and is it optimal or not? And I think we can do it by also tying it to things that we've been discussing over the last 3 days. So, okay. So of course, if company is engaging in wrongdoing, if company pollutes the environment and there are environmental laws, if there's a worker safety issues, there are labor laws, if you are defrauding your consumers, there are consumer protection laws. But what does corporate law add really? And the answer to, in a nutshell, for the non-corporate law people, to simplify it, is care-mark duties. Care-mark duties after the a landmark corporate law decision from mid-1990s, which basically sets the framework for imposing liability on directors and top-level executives for failure of oversight of compliance. So something bad happened in your company and you didn't do enough to prevent it. And of course, the question is, how can we calibrate it? Because naturally, not any time that something bad happens in the company, we will hold you liable for it. So there enters the care-mark decision, right? So care-mark changed director oversight duties from passive to proactive. Prior to care-mark, directors could just sit there, and as long as no one came and told them, look at all those illegalities, they were off the hook. Care-mark changed that. Care-mark said that directors have to be proactive about compliance. They have to install a system that collects information and reports back to them, so it ensures upwards flows of information in the company. And once this system picks up some red flags, they have to address it. They can't ignore it, right? So the basic aspect goes back to deliberate ignorance, right? What care-mark is trying to do is that it mitigates incentives to remain ignorant, right? But at the same time, it creates a different set of problems that we discussed with Zohar yesterday, right? And that's the cost of judicial intervention ex post. Because it would be almost too easy for judges after the fact to come and say, look at all these bad things that happen. If you would have known about them in real time, you would have prevented it. So you should have known about it in real time. Hindsight bias, right? And we're especially worried about it in this context because directors bear the full cost of compliance failures if they're liable for it, but they don't bear the cost of compliance programs. So we would think the directors would make their companies overinvest in compliance, and Gideon wouldn't want to be a director and everything that we discussed yesterday. Okay?
I don't.
So that's where actually care-mark had 2 steps and not 1. The first step is the one that we just discussed, shifting the duty from passive to proactive. The second step was for the court to tell itself that it has to be restrained from intervening in future compliance issues, right? So I'm going to impose liability on you only for an utter failure to collect information, or if I have indications that you were aware of these things and you chose to ignore them, right? So this is different from other realms of private law that Eyal talks about in his book chapter, in a sense that it's not about negligent ignorance, it's about explicitly deliberate ignorance, okay? So, and this is where it gets interesting to me, because it goes back to the discussion between Donald and Zohar yesterday. and Jennifer today in the previous session. So what the courts are doing here is actually not Team Zohar, to use Donald's phrase from yesterday. It's more Team Donald or Team Jennifer from today. In what sense? Let me explain how. So Jennifer actually wrote a paper on Caremark for a book on iconic corporate law cases, right? And she talked with Chancellor Allen, who wrote the decision, and Chancellor Allen explained that in mid-1990s, Delaware law has adapted the differential business judgment rule and also the possibility to exculpate directors. And the fact that the law took a hands-off approach led to a norm in the business community where directors didn't need to do much. And Allen was saying, I wanted to change that. I wanted to kick their feet off the table and tell them, you need to start putting in the effort of monitoring compliance. So I said, you have to be proactive. But at the same time, I was worried about my fellow judges, who maybe know less than I do, that they will intervene. So I'm telling them, you also need to restrain yourself. So I'm setting up the bar high. This is what the standard is. But I'm assuring you that I won't interfere every time I think that the behavior is slightly below the standard, only when it's clearly below the standard. And what I think, that's not Team Zohar. That's actually what kind of Donald was saying, sort of a nudge, right? The fact that you're mindful of the cost of judicial intervention doesn't mean that there's no rule for courts, right? There's rule for courts to say what the norms should be or things along the lines of what Jennifer said in the previous session. So in theory, it sounds great, but it didn't really work. This for the first 20 years. And the reasons, again, are what Jennifer said in the previous session, which is if you want courts to have this role of hortatory appeals and morality tales of saints and sinners, you need to provide courts with opportunity to hear cases and to see evidence from inside the company on what directors knew it, when they knew it, and what they did or didn't do to stop it, right? But without elaborating here with all the civil procedure aspects for the non-lawyers, operationally, this framework translated into throwing all the cases very early already in the motion to dismiss. Because if you're an outsider to the company and you're bringing in a lawsuit for failure of oversight, and you won't have evidence of something that the directors knew when they knew it because you don't have access to discovery. And so cases were thrown out and it was basically an empty shell. So this attempt at kind of calibrating or balancing and solving the deliberate ignorance problem failed at least at first. Then came the recalibration starting in 2019, less than 2 years ago. Right, so it started with the Bluebell case. Ice cream manufacturer has a lot of food safety issues, eventually a listeria outbreak, several deaths, massive product recalls. Shareholders are suing top-level executives for failure of oversight. The Chancery Court, the first instance, froze this case like any other case because you don't have smoking gun evidence that directors actually knew about it in real time. And then the case gets to the Supreme Court, and the Supreme Court is saying, yes, it's true that I don't see any indications of discussions of food safety issues in the board minutes, in the board meetings in the years leading up to the scandal. But that, to me, is exactly why they breached their duties. Because if you're a director of a company, that all this company is doing is selling ice cream, and you don't have any discussion of food safety compliance issues, you're not even trying. Okay, and so you breached your duty. And the way that Chief Justice Trine framed it, the doctrinal hook was mission critical compliance, right? So Eugene in the talk yesterday told us that we should kind of separate between different types of misconduct. So certain types of misconduct, bless you, go to the core of the company's business model, right? So if you're a company that all it does is sell ice cream food safety issue, if you're a startup biotech company having a promising drug go through the pipeline, then it's meeting FDA protocols, right? And so in these types of compliance risks, we feel comfortable in applying enhanced oversight duties, right? We're not just going after cases where we know that you knew, we're going after cases where you should have known, okay? That's mission critical compliance. The other prong, and I won't get too much into it because I want to leave room for the discussion, was they also broaden shareholder rights to information, right? So shareholders now get to inspect the company's books and records, not just formal materials, which are written ex post after the fact by lawyers, but also informal communication. So think about the Facebook Cambridge Analytica scandal. The court ordered, like Mark Zuckerberg or Sheryl Sandberg, to provide all the private emails that contain discussions of what do we do with user privacy and how do we sell or not sell, how do we monetize user data. So I won't get too much into it. I have a paper saying that I think it's a very good thing. And all right, last thing. Everything that we just said was about deliberate ignorance, but I think that it applies also to a large extent also to Max's themes of complicity. I wanted to add one more thing about Max's chapter that I'm looking forward to read this book in 2023, assuming no rockets here in Israel. When I was reading through these profiles and this typology, I kept thinking, and maybe it's too much law and economics, too much the lawyer in me talking, I kept thinking about the outside cost and the legal and the reputational cost in these different categories. Because these different categories of complicity that Max is writing about in his book come with different types of expected legal sanction and different types of expected reputational sanctions. From some types of complicity, it might, going against it might ruin your future business opportunities. Other types, not so much, right? So just an example, Max started with Erica Newland and the Trump administration. So not to be too cynical, but if you're quitting your job, and on the day that you're quitting your job, the New York Times pulls out the red carpet and tells you, write an op-ed about it, then I don't think that the reputational the reputational forces are necessarily for complicity. You still have a lot of future business opportunities, maybe more now. You still have a lot of social esteem from the circles that you care about, maybe more now. So that's a different ballgame than other cases of complicity. So one case, Genevieve suggested I'll talk about on Tuesday, I don't see her with us today, Max, it's involving the DuPont C8 emission case, which is about starting from the 50s, DuPont was producing Teflon. In the process of producing Teflon was emitting this crazily toxic chemical to the air, C8. And in the post-mortem analysis in the 2010s, when they came and they asked the employees, how come you were quiet about this thing all those decades? And they were basically giving the same answers, which was, I'm not going to go against my only opportunity of not just the retaliation that we sometimes can solve with whistleblower protection, but also the community retaliation. They had to switch church several times. They are people who were leaving when they were entering restaurants and everything. So to me, if I was, thank God Max's book is not a law review article, but if I was envisioning kind of a review essay for law reviews about Max's book in 2024, to me it would be interesting to map the different legal and reputational cost in each profile of complicity and among each profile of complicity according to different contexts. So that's it. Thanks a lot.
Thank you very much, Lee. So that's a good time to solicit some questions from everyone. And currently I have on the queue Gidon, and then I'm not sure if Jennifer still wants to make a comment or not, but then Eyal, Edward, and then Max.
So that's a great session, and I have a comment/question to each of the presenters. And again, thank you so much. And thank you, Lee, for, as always, your majestic skills and your ability to bring papers together and set people apart. No,
Beat us against each other.
do not take me seriously. You know what's kidding. So yeah, I love the project. Two quick thoughts that I had, actually three. So one, the distinction that you have in your presentation, I look forward to reading the whole paper, seems to me at least to track the distinction that between action rules and decision rules. So when we're targeting actors, we want them, these were your first two categories, we want them to acquire information, not engage in willful blindness. But your examples of those cases where we don't want information, I thought by and large directed at decision makers and not the actors themselves. My second point is that we can also use carrots when it comes to actors. So the business judgment rule, for example, it says that you will get immunities or a particular immunity or protection from liability if your decision is informed. If it's not informed and you're a corporate fiduciary, the decision turns out to be a bad one, you will face liability for breaching your duty of care. But if it was informed, no conflict of interest was taken in good faith, you get immunity. And the other type that I thought might be interesting to you is partial deliberate non-disclosure. And I don't know if it's the rule anymore because I don't like family law, but I thought that at least once, maybe it's still the law, adopted children cannot receive information about their biological parents, but only up to a certain age. Am I wrong? It's not the law anymore?
You can say whatever you want. I don't see any family law people here.
No, I think
After a certain age.
after a certain age, right, yeah, so it's still the rule. So we have like partial non-disclosure. I don't know, you can do with it if it's helpful and if you're mapping legal terrain. So that was my comment, short comment to you. Max, about your work, and like Roy, I very much look forward to reading it in 2023, and tonight we're going to party like it's 2023 because tomorrow it will be 5 years to Prince's death. But yeah, it's true. But I think unless maybe you read it already, Amos Giora at Utah has a series of books. Amongst them is The Crime of Complicity. His most recent book is called An Army of Enablers. And he addresses the exact same phenomenon that you are addressing, but in other contexts. So he's talking about universities, about the Catholic Church, about all the people on the Olympic team who knew of the sexual abuse that happened along so many years. It's difficult to read the book, but I think it's not in the business context, but you may find it useful. And he also has a proposal for a legal reform, and he took it pretty far in Utah that we should impose liability on bystanders who know that something amiss is going on, something illicit, something harmful, and do not intervene. I'm not sure that I agree with him, but he took a very strong approach there. And Ilana, if I may ask you one question, do we have any information about how one's personal life experience affects her willingness to give? So, and I'm thinking, if I come from abject poverty, but I made it, okay, I can now give to others. Am I more likely to sympathize with or less?
I'm not aware of a study that looked specifically at this question of people who came from low.
So that's a good answer.
Okay, thank you. Jennifer, do you still want to ask a question? Okay. Eyal.
So my question / comment to Max. There's a sense reading your introduction of hindsight bias. So all those behaviors are now condemned, at least in some circles, and now we can judge those who didn't do anything about it. But it's the more challenging task is, before you know that these are horrendous, these are horrible things that are going on, you're unsure whether things are okay or not okay. Are you going to be a whistleblower? And there are some people who blow the whistle every day. I would like to be their colleagues. And perhaps tomorrow someone will whistle the blow about us going to eat meat this evening, and perhaps in a generation, eating meat would be considered like owning slaves a couple of dozens of years ago. So I have the sense that there are the good guys and the bad guys, but in real time, you usually don't, you're unsure whether the bad guys are actually bad.
Max, do you want to answer?
Sure. Just Eyal, or should I comment on things that I've heard?
I would think that you would do that sort of briefly.
Okay, so so quickly on Eyal, I think anytime you use known public stories, you're potentially guilty of hindsight. So my day job is as an experimentalist, and my hobby is to write about relevance to public policy. And I don't know how you kind of get away from it. Certainly my aspiration is to have a forward-looking set of ideas about how to avoid complicity in the future. And I think in many contexts, I think that that's very viable. So I can easily believe that I'm guilty of hindsight bias, but I think it's also clear that many of the complicitors that I plan on writing about had good reason to know that they were doing something wrong. Gideon, thank you for the reference. I did not know of that book, and I can promise you I will learn it in the near future. And the only other quick comment I wanted to make about Roy's comment was, so on Erica Newland, my inspiration isn't that she's an amazing person for quitting. I think the important part of the Erica Newland story is that if this person is pleading guilty to us for being complicit, I think it's an interesting signal that maybe many of the rest of us should think about the ways in which we're complicit as well. So I find the motivation, the intriguing part of the motivation isn't her quitting, but her calling her own behavior complicit, which I find pretty fascinating. And also, that juxtaposes nicely against the hindsight comment from Eyal. I'm done.
Thank you. Thank you.
Yeah, and a question for Eyal. And the package of cigarettes made me think of the research on behavioral change, and especially on the messages on packs of cigarettes. We have the intuitive notion to make them as scary as possible. And a lot of research actually shows that that has the opposite effect. Defensive reaction, people don't pay attention to it, it's too scary. So it doesn't work. And so would that add a legal dimension? The way you present the information. So I get lung cancer, I sue Philip Morris. Philip Morris says, yeah, case because it's on the package. So then I can claim, yeah, but you put contracts in a way that we know is not processed.
So I deliberately bypassed this question by using the example of a message that at least allegedly turns to your system 2 rather than system 1. Rather than trying to disgust people. I agree that using the disgusting messages raise up a series of new questions that I don't think that are that necessarily has to do with deliberate ignorance. So that there's a different issue. There's another issue whether nudges like that ever work. I'm quite hesitant about, quite skeptical about nudges in general, but it's not necessarily part of the deliberate ignorance question.
Simone?
Thank you. This was a really interesting set of talks, and I have a question for Max. Before I ask the actual question, can I ask for some clarification? What is the difference between true partners and believers?
Oh, I'm thinking of true partners as intentional actors who share the same goal. I think of believers, people who suppress any cognitive thought and use faith as a heuristic. Sort of, I've decided that you're the human changing the world. And therefore, I no longer deliberate on my own, I simply follow. So George Shultz in the Elizabeth Holmes story is a believer in the sense that he's no longer capable of taking in any information that would suggest that Elizabeth Holmes might not be the guru she claims.
I find the complicity angle really interesting because I feel like in some ways complicity can be both the person level, the bad apple, but it can also be the system level, just the situation, the group of people are complicit in that. And I'm wondering from a consequence and solution point of view, if we have rationalization, system justification, bounded ethicality, ethical blind spots, how can we encourage actors, whether organizational or human being actors, to be less complicit?
Yeah, so I'm not that far along. The end of the book is going to be about what to do about all this. So I've been taking lots of notes throughout this conference on ideas that may show up there. But if we go back to the conversation with Donald and the gentleman who was the head of the Israeli SEC from yesterday. Yeah. Yes, I certainly come down in favor of more intervention because of the impossibility of solving the individual behavior at an individual level. So while sort of most of my research focuses on the individual, what I know about the psychology of human behavior regarding ethics tells me that we often need structural interventions to create effective change, that we can't rely on minor doses of moral suasion in most of these contexts. But in terms of the broader question, what are the solutions? By all means, send me emails giving me good ideas on that, because that's what I kind of view that as my summer work. So I've been working on the more descriptive side of it, knowing that I want to get prescriptive in this book.
If I can think of anything insightful, I'll be sure to send you an email.
Absolutely. Yeah. I'll do my best to remember to cite you, but motivational blindness may get in the way.
If anyone has another question, Max, your hand was up before. Was it with a question?
No,
or?
I'm done.
Okay.
Yep.
So Ilana, I might have a question for you. So I was thinking about this really intriguing finding of the people who chose not to reveal, yet at the same time, those people were, I had the intuition that you were thinking that they're going to be more likely to think that they should be saved on the Titanic. And ultimately it came out the opposite way. And the people who seem to be more judgmental of others and also more self-centered were actually the people who were more other-oriented in their behavior. So I wonder if you could talk a little bit about that. I mean, I know you said that you don't have the whole story. Is it made so some kind of maybe explanations that I was thinking about is maybe like a warm glow, or people caring about others, being more others oriented also comes with being more judgmental or picky about others' behaviors. And I think about other ways in which you can test that maybe, but I wonder what you think.
I'd like to talk to you about it. I don't have the whole story, but it's my sense that there are different clusters of people. Right? It's not the same people who are really concerned about the other and more judgmental or whatever. I think those are different people. I didn't see a correlation too, which is sort of indicative, but this is the first step.
Interesting. Thanks. So thanks everyone. I'm really happy to conclude and wrap up this really amazing conference. I personally learned a lot from all of the sessions I attended. And thank you, the organizers, for participating.
For all people on this panel, for the chair and for the respondent, and for all those participated from near and far. Thank you very much. We are sorry, no food for you. We tried to send something by FedEx, UPS didn't work out. So next time, we owe you, next time in Israel. with no missiles this time.
It's not true. I'm sending someone from Israel on a scooter. It will get to you in 2 months.
We accept.
Bye. Bye, everyone.
Thank you.